Hi, friends. Welcome to Active Self-Protection Extra. Today over Zoom with the Prince of Attorneys, Terry Johnson, the Executive Vice President of Firearms Legal Protection. Today, we're going to rustle your jimmies a little bit and talk to you about what the Rittenhouse trial says and what it establishes in case law moving forward. My family and my staff are all covered by Firearms Legal Protection because there is no better resource to help good, sane, sober, moral, prudent people after a use of force. They now have a great newsletter available to everyone for free as well. Sign up at the link below and check out their coverage too. Don't forget to thank them for bringing us today's video. Terry, I appreciate you being here, and we've been asked this question several times about what does the Rittenhouse case mean about case law, right?
Right.
And particularly in the media, this portrayal of what does this mean in case law?
Right.
Oh, okay, so straight up, Terry, what does it mean? What case law does this case establish?
Okay. Everybody knows my normal response when you ask me questions like this, and I always say, it depends, right?
Yeah.
Well, coming to you right now, I'm going to tell you it doesn't depend.
There's no depending here.
No depending. It means absolutely nothing. There is no case law established here. In order to establish
case law, zero controlling issues in this outcome for anyone in any court anywhere in the nation.
Correct.
All right, explain to me why.
Even in the same court where it's at, there is no case law. You get two types of laws. You have what's called codified, which basically means your legislative branch gets together, they sign some laws into place, you go through the governor signs and it becomes law, or however it's done.
Black letter law, we call that, right?
Yep. Following that, there may be some nuances in the law that nobody thought about. And somebody may say, hey, I want to challenge this. Now, a judge has got to decide something. A judge or a jury has got to decide something along the way. Once that's decided, then it would go up to the next level, your appellate court. And then the appellate court would review it and say, yes, you applied it right. No, you didn't. And this is what you need to do going forward. And if there's a challenge there, it may go up to your Supreme Court of your state. So in this case, there's nothing to go up. Simply because here the prosecution, because, Mr. Rittenhouse was found not guilty, there is no other bite at the apple for anybody. The apple is actually tossed out at this point. So nobody gets to go back and say, the prosecutor did this wrong, we need to fix it. The defense did this, let's make sure it never happens again. Once those not guilty verdicts came back on all counts, this case will never see the light of day in a state court in Wisconsin again. Right. And because someone's going to ask me a crazy question, and that question is going to be, but the feds. And John, I'll let you jump in on this, and I'll respond to that momentarily about the feds.
Well, so there's this big thing though, is that the state only gets one bite at the apple, and the state cannot appeal an acquittal. They had to prove their case to the finder of fact, jury in this case. Now then, the defense, the person, if he got convicted of something, can appeal the conviction based upon, not upon the facts. No, they got the facts wrong. No, it's the trial court that establishes the facts. The appeals court says, did they apply the law to the facts correctly? And was the law fault?
Or was there something else? For example, we heard a lot of times, and I know we'll probably talk about in another video about mistrials and other things, other egregious behaviors that were done, more so I would say by the prosecutor. But did any of those things affect the potential outcome in this case? And again, those only go up if in fact you get a guilty verdict on a charge. Yes.
So then the fact that we didn't says, now, wait a minute, there's no question of legal application here. So this will never establish case law because it can't by definition.
Correct.
Now let's talk about that other issue that you brought up, that, okay, so this was in Wisconsin. This was in a county in Wisconsin. And so it could be brought up as far as the Wisconsin Supreme Court, but that could only control Wisconsin. So I live in Arizona. You live in Michigan. So these charges would never affect anything in our lives, regardless, because we live in separate states. And well, unless we were in Wisconsin, I guess. But now somebody's going to say, yeah, but what about federal law? And what about the feds in this? And it's the same thing with the feds, right? First of all, he hasn't faced any federal charges. Second of all, if he did, he would have to be convicted, appeal the conviction on some legal grounds of misappropriated action. Then the appellate court decide, yes, something was applied correctly or something was applied incorrectly, hand that back to the lower courts to establish case law. And none of that's happened.
Well, correct. But here's the other thing about this, again, from a federal perspective, if the feds were to come and charge him with something, they're not going to go back and say, in the state court, you did this wrong. They would have to bring charges in the federal district.
Mm-hmm.
So, and I can't remember if Wisconsin is northern and southern or eastern and western, or how they're broken up on a federal side. But let's just hypothetically say the eastern district of Wisconsin. They would have to go there and file charges, basically saying you did something wrong on a federal level. Okay, not on the state charges. They're only going to bring it on the federal charges that the feds would and could bring. So again, now we're talking that district in Wisconsin, potentially the what are they? I believe they're the 7th Circuit. Again, don't quote me.
Yeah, so then if they go from the district to the circuit, from the circuit to the big court, if they want to.
Yeah, so it's a lot. And again, right now today, there's nothing that there's no case law out there regarding anything, the actions of a self-defender, in this case, Mr. Rittenhouse, would ever affect any of us.
So the biggest thing I want everybody to take away from this is Kyle Rittenhouse's verdict gives you nothing in terms of established legal doctrine. Now, some people might say it sets a precedent in the public discourse. It sets a precedent. And I think it's a somewhat debated thing. I actually, as much as there were some frustrations in there for me, I think that President Biden said we have to accept that the jury did their job. And whether we like the outcome or not, the jury did their job, and we must respect that and respect what the jury did. I agree. The jury did that job. I personally thought the outcome was a correct outcome. And so yes, we go from there. But no case law was established. Nothing that's going to affect your life in terms of how the prosecutor in your jurisdiction might deal with your case. So let's make sure that we know that. But of course, this then kind of sets us up into the next part, which to me is about the trial in the media versus the trial in the court. And that's what's going to be our topic next week. Terry, I think this one is misunderstood because of the idea of every case establishes law for every other case. So thank you so much for straightening us out.
John, thank you.